Yeah, we will be going to Dhiran Chinnamalai. Can you unmute, Jagdish? Jagdish, you have to unmute.
Namaste, Suswagatam, and welcome to our Sunday edition of Gyan Ganga Words of Wisdom on our Virat Hindustan Sangam social media channels. As you all know, we are on various platforms at the same time, not just on YouTube and Facebook, but various social media platforms at 8 p.m. on every Sunday. Today, we have a very important discussion. The Supreme Court review petition to be heard by a 7-judge Supreme Court bench on the Sabarimala review petition, and today's discussion is on the issues involved. And we have Dr. Subramanian Swamy, and with him is Dr. M.R.Venkatesh, who's a chartered accountant turned lawyer and who has been author of numerous books and has been championing many of these causes. We also have Mr. T.R.Ramesh, who has been in the forefront to protect our Hindu temples, especially in the state of Tamil Nadu, and has fought numerous battles with the various government agencies to protect our temples. So without much introduction, I am going to move to the next item of paying tribute to some unsung freedom fighters. This time we are featuring Dhiran Chinnamalai of Tamil Nadu.
Dhiram Chinnamalai, born as Thiyatagiri, on the 17th of April 1756 at Mellipalam in Erode district, was a prominent regional chieftain who played a significant role in early resistance against the British expansion in South India. He emerged as a key figure opposing the revenue policies of the British East India Company, which disrupted traditional Paligar autonomy and local sovereignty. Known for his sharp military strategy, he used guerrilla warfare to challenge British forces. Around 1801, his army disrupted British movements near the Kaveri River. In 1802, at Odanilai, he successfully resisted a British attack. Again in 1804, at Arachalur, he proved that determined local resistance could stand up to a powerful empire. In 1805, he was captured and executed by the British at Sankagari Fort. His death marked the suppression of a significant phase of resistance in the Kongu region. In recognition of his historical role, the Government of India issued a commemorative postage stamp on the 31st of July 2005. Tamil Nadu government continues to celebrate his legacy through memorials and annual tributes. Today, he is remembered in regional history as an important early figure in the struggle against colonial rule.
Virat Hindustan Sangam pays tribute to this great freedom fighter. So with these words, it's over to Dr. Subramanian Swamy to initiate today's discussion on the issues which are under review before the Supreme Court in the 9-bench Constitution bench. Over to Dr. Swamy.
Thank you, Jagdish. It'll take a long time if I were to enumerate all the things that the Supreme Court has put forth. But I will select some of these which are important for our function, for our conference today. I would like to point out that the first time the temple issue was taken away from politicians, and particularly the DMK politicians, was when I was able to do it for the Sabarimala temple, the Shiva temple, which the DMK had sworn that they will take it over and replace the Shiva temple there, and then they will run it against all the Hindu ideas and so on and so forth. Unfortunately for them, they got a thrashing in the courts, and which they appealed to the Supreme Court, and the Supreme Court gave them a bigger thrashing. And that is Sabarimala thing has been a milestone for all temples, except where there is something special that needs to be considered, and that's where the today we have the question of the temple that we are considering today. Now, what I would say is there are 4 or 5 major things that the today the people who the eminent people who the 2 of them who have come here, T.R.Ramesh and and uh, and I must say his name is Venkatesh, just to make sure. So, because he was looking up, so I thought, let me check what's the problem. Anyway, we are there. These are 2 very great scholars, even though their field of work is different, but they have acquired this knowledge, and that's why we are having this function. The first and foremost is, what is the scope and ambit of the right of freedom of religion under Article 25 of the Constitution of India? There's so much confusion that I think this is one of the things that the 2 scholars here should put forth. What is the scope and ambit of the right of freedom of religion, which is given in Article 25 of the Constitution? Second is, what is the interplay between the rights of persons under Article 25 of the Constitution of India and the rights of religious denominations under Article 26 of the Constitution? So this is something also we would like you to explain to us. What is the difference between these 2, which have been put separately? Then the third thing is, what is the scope and extent of the word morality under Article 25 and 26? Please read the Constitution, and the word morality is brought in Articles 26 and 25 and 26, and whether it means to include constitutional morality or not. And there's a debate that is going on today. So on this, I would like them to apply their mind. What is the meaning of the expression sections of Hindus occurring in Article 25 bracket 2 bracket B of the Constitution of India? What do you mean by sections of Hindus? Hindus are Hindus. Why sections? Why have these been separated in the Constitution of India? And finally, whether a person not belonging to a religious denomination or religious group can question a practice of the religious denominations or religious group by filing a PIL. So these are the things which I consider, although there are so many issues which are independently of this, but I think these 5 questions should be addressed, if not all 5, at least a good number of them, and make the public understand why we are making so much effort to see that these things become clear to the public. Over to you, Jagdish. Jagdish's voice is not coming.
I would now request Mr. T.R.Ramesh, who is
can't
part
hear
of our panel today.
Jagdish ji.
Okay, please go ahead.
Ramesh, you can go ahead.
Mr. T.R.Ramesh.
Okay. Thank you very much, Dr. Swamy. Thank you very much, Jagdish ji. Dr. Swamy read out the 7 questions that have been formulated for the 9-judge bench to review in the Sabarimala matter. As we can see, the word Sabarimala does not occur among the 7 questions. Nevertheless, it's a review bench of the Sabarimala judgment. And certain important questions have come up. Like if you take the last question, 7th question, whether a person not belonging to a religious denomination or religious group can question the practice of the religious denomination or religious group by filing a PIL. Now, a PIL, as we all know, is a pro bono publico petition, where a person files a case on behalf of those who cannot file a case. Usually, today, let's say if I file a petition, public interest petition in the Madras High Court saying that the conditions in Stanley Medical Hospital is not good, it should be improved, there's rampant corruption there. The court cannot question me saying, are you a person who's taking treatment there? When did you last take treatment there? I'm doing this as a public service. So for a society purpose, a person not exactly affected may file a case, PIL, and Dr. Swamy has done it many times, like the voter receipt, like the mail visharam, that matter, and the corruption matters and all that. So it is done for the general public and all that. But whereas in the religious matter, a person not belonging to a religious denomination questioning the practice of another denomination, like what is good in one religion may be haram in another religion. What is halal in one religion may be not at all to be practiced in another religion. So if you go by that and say that I don't like this practice, I think it's generally wrong, and question it, that's what happened in the Sabarimala case. Persons not belonging or not devotees of Ayyappa, they filed the case saying that women of all ages should be allowed to the temple. So that's why the 7th question has come. And I hope the court gives an emphatic no as the answer. Mischievous petitions can never be allowed, while public interest litigations exactly does not stress on locus. In certain cases it can, and in cases of religious practices it should. Now, if we come from the first question, what is the scope and ambit of right to freedom of religion under Article 25? I think it should be read along with what is the interplay between the rights of persons under Article 25 and the rights of religious denomination under Article 26. Rights under Article 25 are individual rights. The individual rights of a citizen to profess, practice, and propagate his religion is the right guaranteed under Article 25, subject to certain conditions. The first conditions are public order, morality, and health. And there is a rider kind of a thing in the second thing, which says the government can regulate or restrict any economic, financial, political, or other secular activity which may be associated with religious practice. This, in my humble opinion, is something borrowed by the framers of the Constitution rather unwisely, and rather just to copy. These words have been taken from the Adelaide Jehovah Witness case. In the Adelaide Jehovah Witness case, these words and some other words have been used by Justice Stark. He says, so the doctrines of a declared body, whether they be religious, political, economic, or social, innocent or injurious, are all prohibited. Okay, they are all prohibited when? Whether they be or not prejudicial to the defense of the Commonwealth or the efficient prosecution of the war. That is, there is a wartime law. Then you can't say it is my religion to oppose the government. It is my fundamental right to oppose the government on religious basis. This is the crux of the Jehovah Witness case, which was quoted during the Constituent Assembly debates and also borrowed by the Shirur Mutt while giving the Shirur Mutt judgment. So, this has to be revisited. Article 25(2)(a), because there are no great examples of how an economic, financial, political, or secular activity may be associated with religious practice. in Hinduism particularly. So it is an excuse for the government to continue to control the Hindu religious institutions even after the constitution coming into place. And that's why Jehovah Witness case was quoted. And this needs a lot of elaboration, but I'll stop here now. And as far as B is concerned, providing for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. This is where the sections of Hindus come. So throwing open is already dealt with untouchability under Article 17. In that manner, this is a superfluous provision in Article 2B, and it only targets Hindu religious institutions. Throwing open could also mean throwing open mosques for women, throwing open denominational churches to other denominations of the Christian religion, but making it only for the Hindu thing is again arbitrary, discriminatory. If we go to the third question, whether the rights of a religious denomination under Article 26 of the Constitution are subject to other provisions of Part 3 of the Constitution, this appears to be, of course, it is framed by their lordships in Supreme Court. I have great respect for them, but if anybody else had framed it, I would say it's a mischievous question. Because in Article 25, it very clearly says it's subject to other part. In Article 26, there are no such wordings. The law, the statutes, and even the Constitution, wherever possible, wherever applicable, should be given a plain reading only. They should not be interpreted in a quixotic way or in a roundabout way. There is no need. Article 26 very clearly says only 4 things. It doesn't say it is subject to any part of the Constitution, whereas Article 25 says, which means 25 is subject to 26, not the other way around. So that question, probably the Supreme Court wanted a no for this answer and they framed it. I do not know. So the scope and extent of the word morality under Article 25 and 26. Now, where does morality come in Article 25 and 26? It says public order, morality, and health. Similarly, in 26 also, it says the same words. Have you ever heard of public order, public health, and public morality? Public order is law and order. Health, what we saw during COVID time, it doesn't. The health here doesn't deal with the individual health. One cannot go to the temple and say, I don't like the smell of the camphor, or I'm allergic to it, so don't burn camphor in the temples. It is not subject to individual health. It is subject to public health. And morality is public morality. What is considered as immoral should not be there. That's all it means. The constitutional morality is a legal fiction, in my opinion. It's a legal fiction. And if at all it comes, the constitutional morality, I would give one example. Under Article 368, there are 3 ways of amending the Constitution. One is through simple majority for certain articles. One is through a special majority. The other is with a special majority and with the consent of the states. Whereas, if the court, either the High Court or the Supreme Court, chooses to interpret the Constitution in a manner that it would amount to amendment of the Constitution itself, a different meaning is given to the Constitution itself, then it is an instance of the court violating the constitutional morality. They are indirectly invoking 368, which can be done only by the Parliament. So constitutional morality is not dharma. Constitutional morality is not 10 commandments. Constitutional morality is not Quran either. It is a legal fiction, in my opinion. So the court should, the senior counsels arguing before the court in my opinion, should argue to that effect, because constitutional morality can undo general morality and traditional morality. Then the other question is, one minute, I'm just getting the question. Sorry, what is the other question? MRV?
1 minute. Tejas, can you display
Okay.
the thing?
What is the scope and extent of judicial review with regard to religious practice as referred to in Article 25? The judicial review with regard to religious practice came up for consideration in Shirur Mutt, where Shirur Mutt, though broached upon essential religious practice, it did not curtail to the way the government wanted it to be. In Adelaide judgment, which is quoted, the court in Australia said it is for the individual to choose his essential practice. Let's take a denominational temple, and let's say that there are 100 persons belonging to the denomination. For one of them, Annadanam could be an essential practice. For another, it could be the festival of the temple. For another, it could be the archana being done with some particular flowers every day. So the devotees chooses the essential practice within the traditional set practices of the temple. The court should not get into it, what is essential, what is not essential, whether dahi handi is essential or not. In fact, there is a judgment by Justice Ramana and his two companion judges, where a devotee filed a petition in High Court, lost it there, and again came to Supreme Court. It's called a Srivari Dada versus Tirumala Tirupati Devasthanam, and where Sabarimala argued, and court said these are matters of religion which a writ court cannot go into, and that is the correct approach. If there are certain established traditions and there are some disputes about it, it should be a civil court that should deal with it with the evidence and records and documents and all that. So the extent of judicial review with regard to religious practice should be kept to the minimum and should not be dealt with by courts at the drop of a hat. And what is the meaning and expression of sections of Hindus? It's a very, very interesting question. We have some points. Our Dr. Swamy's research team and others have a point in it. But at that moment, I don't think we should reveal it. But why this question came is, the Sabarimala judgment, the majority chose to include women as a section of Hindus. So they said throwing open would also mean to throwing open to all women. And that's why this question has come. To my limited knowledge and to the extent possible, I have gone through all questions as directed by Dr. Swamy. I would like my colleague and my counsel in courts, Shri M.R.Venkatesh or Dr. M.R.Venkatesh, to speak up now.
Thank you, Ramesh. I hope I can start it now.
M.R., we can't hear you.
Go ahead. I can hear
Hello?
you. I can
Am I
hear you.
audible?
Yeah.
Yeah.
Yes.
Yeah. Okay. See, like a good counsel, he never listens to me. That is why I am not audible to Ramesh. That is the problem. Okay. So now the point here is, if you take the Bhagavad Gita, the same dialogue between Arjuna and Krishna goes on over 700 verses. And on several occasions, Arjuna is compelled to use several names for the same Krishna. Sometimes Janardana, sometimes Madhusudana, sometimes Krishna, sometimes Parthasarathi, and so on and so forth. So many names in so many verses. The same Krishna, the same Arjuna. In other words, we have to always keep in mind that we are, and each name, what Arjuna uses is contextually driven to the text that he possesses, O Krishna. In other words, Hinduism is a very complex religion where each and every act has got its own significance. We go and tonsure our head in Tirupati, but we don't do it elsewhere. We go to Chidambaram, which Dr. Swamy alluded to at the beginning, and ask for only one prayer is possible there, that is moksha. We don't go and ask them, I want this, I want that, my daughter's marriage, my son's education. No, nothing. It's a simple one line prayer that can be made in Chidambaram, which is a votive shrine, and we say that, look, please grant me moksha. So each place has got its own historicity, its own significance, the way the Lord is addressed. So there are several traditions. Unfortunately, the framers of the Constitution had a huge handicap. They had probably little or very less understanding of these traditions. And even if they had, they were in minority, and the majority which was there were English-speaking people, anglicized, and they wrote the Constitution in a foreign language, and they borrowed idioms and phrases from a foreign language or a foreign system or an alien religion, which is Christendom, and tried to fit it to this great ancient land. That is why it is appalling for many of them, left to themselves, that they will find Lord Balaji being scantily clad on a Thursday if they go to Tirupati, and they say that Lord must be adorned in a three-piece suit. And otherwise, they will find that this is not in line with the moral values that they have cherished or imbibed or embraced or they have embedded into the Constitution. Now, that is why there is an excellent book by the Cambridge University. It talks about the endurance of national constitutions by three scholars, Zachary Elkins, Tom Ginsburg, and James Milton. They have gone into what is called as the constitution endurance, and how long does a constitution remain in force or is relevant. After authoritative research, the authors of endurance stumble upon a series of exchanges, communications between James Madison and Thomas Jefferson. And Thomas Jefferson says the dead should not govern the living, meaning that the Constitution must be rewritten for every generation. Now, the problem is the Honorable Supreme Court, when it came to a simple question, whether fecund women of the age 10 to 50, should be allowed to come to Sabarimala, they took about all sorts of arguments. They looked up into the Shirur Mutt decision of the Honorable Supreme Court, S.P. Mittal. They went into a range of judgments. And of course, they went also abroad, like Jehovah's Witness, like what Ramesh quoted. And they came to an irresistible conclusion that it is a question of equality. And if you put an embargo on fecund women from coming up to Sabarimala shrine, you are transgressing the issue of touchability and bordering on untouchability. And hence, it was, to put it very crudely, a revolt against the constitutional morality. A thought of putting an embargo on the women is a revolt against the constitutional morality. Hence, they came back and said, no, this practice is not done. Little did the four wise men and one wise woman. Of course, the wise woman did not agree with the four wise men. And the four wise men did not understand one simple thing, that women in the southern part of the country, as a nature or as a practice, do not enter temples when they are in a menstruating period time. They don't enter the temples. And Ramesh tells me that that is also a part of the rules in the Tamil Nadu Temple Entry Act, and that is embedded as a as some sort of totemic status. That's given a totemic status. Now, not only that, when this judgment came, my hairdresser, or you call him barber, whatever, told me a very important thing. He said, "Sir, in my home, the ladies during this time do not go and light even the traditional lamp in a Hindu house. And they keep away. Now you say it is impurity, it is untouchability, it is self-imposed restriction, social taboo, whatever it is the social practice which has held true for centuries, and that is only taken to a very logical conclusion for one shrine, which is Sabarimala, which says for 41 days you have to keep a vrat, and that vrat biologically is not possible between a fecund woman, and hence she must be excluded. And believe me, my sisters, my cousins, my wife, my mother, my mother's cousins, all of them, when the males in the family go on our annual vrat and yatra, abide by the same amount of discipline, and they have held on to a moment called let us wait, the right to wait, and at a particular age, when they reach a biological age, they have agreed to go and visit the temples, and many of them have come along with us after age. It is this restraint, it is the self-imposed restraint, not the constitutional one, that makes us a civilization. And that is why in other parts of the world, as an interpretation of the constitution is being done, you can have a Renan Martin grammar book on your left-hand side, and you have a Webster or Oxford on your right-hand side. Interpret each word, that, like for instance 25 that Ramesh pointed out, public order, health, morality, find out the meaning of these things, and the sigma of the meaning of these things cannot be, should not be, must not be interpreted as what the constitutional framers originally thought or believed it to be conveying a meaning insofar as 25 and 26 is concerned. And this will hold true for all the articles, but since we are talking only about Article 25 and 26, I thought I will dwell only on this point, that you cannot take a hair out of an elephant, then say that the elephant will be defined by defining the hair of the elephant. You have to take all these judgments, you go through it, not through by dissecting the word by word, but also the aggregate of it. Now, if you take the aggregate of it, in 26, denomination becomes a huge challenge. The word denominations etymologically owes its origins to the word, a Latin meaning de nomo, meaning of giving name. Now, why did it happen? In Christianity, somewhere around 16th century, the Habsburgs Roman Empire, and in that this word started used to describe what is called as Christian denominations of Roman Catholicism and Lutheranism. So the first two denominations were Roman Catholicism and Lutheranism. And then today Christianity has 45,000 denominations. There is nothing called a public church in Christianity. Either it is Anabaptist, Seventh-day Adventist, Protestant, Catholic, you name it, without which there is no church. It happens exactly the opposite. And today I was discussing with Ramesh, and we were appalled to know that 95% of our temples are public temples. And they are not denominational. Because why? We don't fit into the tradition of denomination first given by Jehovah's Witness, then taken in Shirur Mutt, fortified by S.P. Mittal in the 80s. Now this, I think, puts a serious lacuna on all of us in understanding our temples. So there is a private right to worship under 25. There is a denominational right under 26. Now the constitutional framers are trying to say that right from Tirupati to Madurai to several other temples are neither in the denominational fold, and hence they come under the non-denominational fold. And once they are in the non-denominational fold, they are as good as public spaces like, say, a park, a beach, or a railway station. So, an entry to a park or a beach or a railway station cannot be barred for a woman, whether she is of 10 years old or 50 years old or fecund or otherwise. So, their argument is we must allow them. So, now the crucial question, therefore, is how do we bring denominations, temples into the denomination fold? If it is, it will acquire that right under 26. Now, there is a specific procedural responsibility cast on temples which claim to be denominational, because they have to go to a lower court, a civil court, and say, look, I am a denomination, and that will take 10 to 20 years to be declared as a denomination, if at all you prove that you are denomination. So a Marthoma church need not have to prove anything. A nearby Sunni mosque need not have to go and prove that it is a denomination of a Muslim religion. But a Madurai temple or a Tirupati temple has necessarily to go to a lower court to prove this as a denomination. Now, even if it is a denomination, the question that Ramesh asked or the Supreme Court has posed is whether the individual right will override the denominational right, whether 25 overrides 26, when on plain reading, 25 is on 4 exceptions: public health, order, morality, and subject to other parts. Whereas 26 is only on 3: public health, morality, and order. So 26 must definitely override 25. But there is a catch here. If we can see the Constitution of India, the preamble, it gives us liberty of thought, expression, belief, faith, and worship. And that is the basis on which Article 25 is framed or actually fabricated. Now, 25 says, subject to public order, morality, and health, and to other provisions of this part, all persons are equally entitled to freedom of conscience and right to freely to profess, practice, and propagate religion. Now, there is an interesting thing which I would like to bring. If you are going to freely practice a religion, it must be what the religion or the shrine or that particular place holds in. You cannot say, since it is a public temple, even assuming for a moment that it is, that I will go with a beer bottle and say my right to practice is to drink a bottle of beer in a temple. And that must be guaranteed under Article 25. It is obnoxious. But this is what the argument finally falls to, that you want to have a Article 25 unhinged, completely without any let or fear of any other articles, without any morality, and only, now if I have to say that I have to go to Tirupati, I must submit myself to what the spiritual and religious practices of that temple has been upheld for several years. Now I cannot go to Tirupati and say I will not do certain things. Likewise, I cannot go to Padani and say that I will not do certain things. This is a practice. If I practice what is being already practiced, that is what is given a protection under 25. I cannot create a separate practice. I must follow the practice that has been done by the people. So what the Supreme Court, or the argument that has been posed before the Supreme Court, is 25 is an unhinged right. 25 is completely incapable of being interfered by any articles of the Constitution. Hence, individual rights prevails over community rights, which is exactly the opposite of what the Constitution always argues in other matters. It says the group rights or the societal rights or the government rights always overrides the individual rights. But here I do not know why they went overboard. And lastly, but not the least, I would like to say that the word propagate and, of course, right to practice and propagate and other parts of the religion of proliferation comes from a gentleman called Ratnasamy. I went into the Constituent Assembly debates. Even for yarning, this Ratnasamy did not open his mouth. But only one occasion he opens his mouth. And that is when he says that he is a part of a subcommittee that is formed to protect the minority interests, and the committee that formed the fundamental rights gave their report to the minority committee, and the minority committee examines the fundamental rights given to all people and says we will look into it, we will have a right of veto, goes through it, and at that time Swamy says that religions such as Christianity and Islam were essentially a proselytization religions, and provisions must be made to permit them to propagate their faith in accordance with their tenets. In other words, what 25 gives you is not a right to propagate because Hinduism never proselytization, never happens in Hinduism. And this type of framing of the constitution, this type of reading of the constitution, this type of understanding of our constitution, this type of interpreting the constitution, and this type of shutting our eyes to our civilizational needs in the aggregate is hurting us very badly. I only hope the Supreme Court will rise not only to its full stature to understand that this civilizational distortion has to be remedied. It will answer all the questions decisively and in the favor of the Hindus who want that this civilizational right, the religious rights, to be fully protected, and protected not in the sense of a government interference, but cognizant of the fact that this is a divine right, this is a civilizational right, this should not be interfered at all by any powers that comes in. I think I've taken a few more minutes than what I was supposed to, but I'm sorry if I exceeded my time limit. Thank you, sir.
Thank you, M.R.Venkatesh, T.R.Ramesh, and Dr. Swamy for those initial points you all have made. Before we go to Ramesh, Swamy, I want to know from Dr. Swamy if he wants to make any comments on these two expert panelists we have, or we'll go to Ramesh, Swamy, and Dr. Aravind Chaturvedi. T.R.Ramesh, you wanted to say something.
Yeah, I just want to check with MRV, the Chartered Accountant turned advocate, Chartered Accountant come advocate, that can we compare the individual rights under 25 and 26 to that of a right of a shareholder as an individual shareholder and the right of a company? Because the individual shareholder has his rights, but he cannot go and amend the memorandum or article as an individual. He has to abide within that, and he cannot take management decisions. So 26 is 26, it's group rights, and your right under 25 is limited to the extent that you can partake within the framework of the religious institution. Am I correct in saying so, MRV?
Yes, more or less you are right. That always the individual right has to be subordinated to the group rights. And that is why the framers of the constitution were using other parts of this chapter, other parts in 25, whereas they consciously avoided using it in 26. So the distinction itself tells you, the words themselves speak for what it is. And your interpretation.
But in the Venkatramana Devaru, the court said otherwise.
Yes, that is the problem.
They are guilty of constitutional immorality.
No, the problem is the constitution is seen as a social document and comes from the social contract theory, which is to say that you are an individual, I am an individual. We both have entered into a contract to create this constitution. Unfortunately, this will not hold true in civilizational settings like India, where there are embedded group rights. Unless we cognize that, and 26, I am told, has certain unique characteristics, which we will have to test it on the day. I hope senior advocates test it before the court, and that will bring some sort of quietus to this matter. And 26 has to necessarily be read above 25, or 25 should be read below 26.
Dr. Swamy, any comments, Dr. Swamy?
Thank you. I think Ramesh Swamy wanted to say something before we take Arvind's view and then go back to the panelists.
Okay, quickly. Dr. Swamy, my main question is First, some observation. MRV, you said there's a restraint about women waiting for their chance to go to Sabarimala. I think that restraint is more of a tapas. That's how I look at it.
Yes.
That restraint is more of a tapas rather than a restraint, and they're not being held back. I mean, that is just my personal observation. And in terms of traditions, as you said, if you go to Kerala, you're supposed to remove your shirt. You can't go to a temple without removing your shirt. That is that practice of that local temple. So I just wanted those two examples. Dr. Swamy, I just want to ask, you had written a letter to the Tamil Nadu government.
Yes.
This, in somewhat, it is related to the temples and the right to worship and things like that, right? Very similar. How is that related to what we are discussing today, Dr. Swamy?
Well, it's it's a question which will take a little time. Maybe you can have a separate session later.
We'll have a session. We'll do another session.
Yeah.
Okay. But my general observation, I'm sorry, I'm being a little pessimistic.
Yeah.
The Honorable Supreme Court is in current dispensation. I don't think, it is going to be a very, very tough battle, MRV and T.R.Ramesh.
Yeah, that lady is crazy from Karnataka.
Yeah. So anyway, so that being the case, Dr. Swamy, there was one question posted by T.R.Ramesh in his Twitter handle saying that how will BJP support this? I am telling you now, BJP will betray the Hindus. They will definitely betray us. They will do something or the other to quell this or kill whatever even this question of a review by the Supreme Court. I'm guaranteed, and betray the Hindus once again. And Hindus will still, because Hindus will believe him and blame Nehru for this. I think that is what we're going to end up doing.
BJP already betrayed in Swamiji's case, Swami Dayananda Saraswati's case.
Yes.
They betrayed. They did not file a counter for 2 years. They kept quiet. And after the judges relegated the matter to the High Court, the Solicitor General gets up and says it's the government policies that temple should not be under government control. Why didn't he say that while the hearing was on? He said that after the order was dictated.
But one fundamental thing, Dr. Swamy, why are we always discussing only temple? Why are we not? I think MRB kind of brought something. Why are these things, when they say you can free to practice religion, why are the same rules not applied to other religions, Dr. Swamy?
First, you get
the same constitution, correct?
First, you get your Hindus correct in the correct path. Then we can go after the other religions, saying that this is a Hindu majority country, and you will have to make certain alterations which you practice in other countries, but you cannot practice in India.
Okay, that's it. Arvindji, you can go ahead next. You're muted, Arvindji. You're muted. Can you unmute yourself, please?
Thanks, the experts, M.R.Venkatesh and T.R.Ramesh and Dr. Subramanian. Swamy, I'm not an expert in this matter, but I have some common questions which are basically reflected when you talk about the case. And initially, when we started the show today, discussion today, Dr. Swamy had mentioned those 7 points. My question is slightly different, and any one of these 3 can answer my query. First query is, of course, purely legal. The kinds of petitions that were filed in the Supreme Court after the Supreme Court judgment of 2018, what nature of the petitions were these? I mean, were they representing only the gender issue? Were they representing the denomination issue? Were they representing the right of the particular section of Hindus, or what? Number one, which any one of you can answer. Second question is, the temple issue, the temple property, the temple rules, the temple culture always belongs to a deity. For example, in Ayodhya issue, we know that one party was Ram Lalla Virajman. Ram Lalla Virajman was treated by court as the owner of the place. So the deity has the ownership. Now, in this case, whether deity is having any role to play, whether the court judges have considered either in 2018, or are they going to consider in the review the rights of the deity, or the deity is covered under denomination, because each denomination may have its own culture, definitions. So whether deity is covered under that. My third question is whether these 9 judges who are going to hear these review petitions, are they expert in religious matters? They may be expert in legal matters, but are they equally expert in religious matters? And therefore, are they allowed to consult the Dharmacharyas or Shankaracharyas or expert in religion before they hear the review petition? So these 3 questions, these are basically common questions, maybe representing the common people.
M.R. Venkatesh.
Let Ramesh answer these questions. These are easy questions, so Ramesh will answer. You are muted.
T.R.Ramesh, you are muted.
Okay. First of all, the Hindu Dharma Acharya Sabha, after Puja Swami Dayan Saraswati Swamiji attained Mukti in 2015. After that, the Hindu Dharma Acharya Sabha, when the Sabarimala judgment came in 2018, they miserably failed even to pass a resolution in the Acharya Sabha meeting, which happened in October 2018 in Rajkot. Similarly, they miserably failed to protect the interest of ancient mutts, which were being demolished in the name of corridor. In the name of corridor in Puri. Now the Acharya Sabha is trying to intervene. Now they are waxing eloquent on Sampradaya instead of denomination and all that. Hope at least now they will, if they be heard, it will be good. But as far as the court being experts, the courts has taken the service of an amicus. But again, the question comes, how much expertise does the amicus has in the matter? They should ideally consult the Dharmacharyas. They should consult the Agama experts. And as far as Sabarimala is concerned, they should consult the experts in Tantra. The covenant between the Union of India and the Travancore Kingdom, there are many clauses in it, and one of the clauses is about religious institutions, where it is said that the Tantri, the chief priest, will be the final authority in all matters of religion. That should be honored by the Union of India. It's a sovereign promise. Indira Gandhi failed many of the sovereign promises. This should at least now be looked into, and the Tantri's opinion based on the Shastras should be final. The court should invite the Tantri, like the division bench in 1991 in the Sabarimala issue in Kerala. They did it.
Okay.
The Justice Paripurnam and Justice Marar, they took the opinion of the Tantri because as per the Travancore Act also, the Tantri is the authority in religious matters. The court is not the authority.
Correct.
The court should be afraid to get into religious matters. They should make a open statement that we are not experts, we are not getting into it.
That's the point.
Justice Ramana did it.
Yeah.
In the Tirumala Tirupati matter. So this is my humble opinion, and I hope the court sees the truth in it.
Dr. Swamy, you want to comment on
First
this?
question about the petitions. Majority of the
petitions filed are primarily about Sabarimala tradition only. Okay. And also that Sabarimala belongs to a religious denomination. It's very funny that a unique custom, a unique practice, a temple is open only for a few days in a month. It is a forest temple. If you have to go there, you have to observe a vrat, and you have to wear a mala. You have to carry 2 coconuts filled with ghee and piety, and you do a lot of these things. And the judges went ahead and said the Ayyappa devotees are no different from other Hindus. Amazing judgment, amazing. So anyway, the denomination question should be seen from the point of view of Sampradaya. I am a Hindu sect. I can go to the court and say, in 1987, the Parliament adopted the Hindi text of the Constitution as the authoritative text, and it passed Article 394A in this regard. And therefore, I come to the court and say, I am a Sampradaya, protect me with the fundamental rights that Article 26 guarantees. The court cannot say, no, 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 I will take the Oxford Dictionary and go into the meaning, and that too, I will take the Oxford Dictionary of 1897 and take part of the meaning and decide who is a denomination by that. That would be nonsense. So that's what they did in 1954. They should do away with it now. They should go with the Hindi text as far as Indic religions are concerned. Pratyek Dharmik Sampradaya is the term found as an equivalent for every religious denomination found in Article 26. Ya kisi anubag or section thereof. So, I am an Indic religion. I am a Sampradaya. I have a Guru Shishya Parampara. I have so many things which Abrahamic religions do not have. Don't treat me at par with them. I rise above all.
Just, I think MR or Mr. T.R.Ramesh referred to the word denomination as used in our constitution from some Australian case of, I think, one of the Christian missionaries there in Australia. Can you tell us some light on this, the various the word denomination, how it came about?
No, the word denomination meaning came from Oxford Dictionary, 1897 edition. The dictionary had 5 meanings, and the 5th meaning related to religion. There too, in the 5th meaning, there are 3 or 4 parts. The first part was saying a group of people called by the same name. Why didn't the court take that? All Ayyappa devotees are called Ayyappanmar. The court didn't take that. It also says sect. The court didn't take that. It took a meaning saying that to be a denomination, you have to have a common name, a common faith which you believe to be conducive to your spiritual well-being, and you have to have a common organization. A common organization is a church-oriented definition. In the subsequent S.P. Mittal judgment which came in the 80s, the spiritual organization, the spiritual word is gone. Court did not like it. It just took the word organization. See, as far as Hindu religions are concerned, we may belong to one Sampradaya, we may belong to Vallabh Sampradaya, but we'll go to other temples. We will welcome other acharyas. We will honor them. But whereas in Christian thing, you have to belong to a church. You have to be an identifiable constituent member of the church. Because from baptism to burial, that is very important. If you do not belong to the church, you cannot have your child baptized there.
And you have to pay a subscription.
Yes.
You have to pay. To
pay a subscription, you have to be an identifiable member of the church.
Yeah. And it is basically a head count one, where each church will say how much members are paying subscription and what. And there are Chinese walls between each of these denominations, that during COVID in Chennai, there was a huge furor of a denominational doctor dying and to be buried in another denomination's burial ground. They would not have it. They said, no, he cannot be buried in our burial ground.
So his body was exhumed.
Their body was exhumed, and it created quite a stink, pun unintended, but that's what it is. So you see that in our traditions, morning I can go to a Shivan temple, evening I go to a Vishnu temple, in between Sai Baba temple, and go to some other place where I can say that there is no God also. All these are accepted as our way of living, thinking, whatever you may say. So the core issue is, we have started looking at a denomination in an English language created for European Christendom and thrust it on poor South Indians, where the temples alone are there. Now, North India doesn't face this problem because Aurangzeb sorted out this problem by demolishing all the temples. So for us, the problem remains, and this has to be sorted out. Hopefully, the Sabarimala judgment, review judgment, will sort it out.
Rameshji,
no, Dr. Swamy, go ahead.
I have one very short question.
No, 1 minute. Dr. Swamy has a point.
Yes, short question, which for a future if a person becomes a religious minded person and he also happens to be a Brahmin, uh, should his children who become lawyers and doctors be also known as Brahmins?
In today's scenario, the government scenario, it is Brahmin by birth or other caste by birth. But Dr. Swamy has always held that you are a Brahmin by behavior or by practice.
Yes. Yes.
But what the government records, how they record is by birth only. In future, that's a very good question. It's the word within quotes, in future.
But I think somewhere we should begin this in written forms, seminars, etc. Somewhere where this idea that somebody can be anything, but if he was born a Brahmin, he's a Brahmin, that we should not accept, or a Kshatriya.
Dr. Swamy, that brings us the question now. Recent judgment of the Supreme Court: if you convert, you no longer belong to the SC/ST communities, and you no longer can claim it.
Yes.
And politicians are saying we will safeguard your SC/ST status even if you convert. But they are not saying we will throw open your churches and mosques like that, like we do for Hindus under Article 25(2)(b). So if SC/ST thing they want to continue after conversion, even though the Constitution is very clear on it, even though the Supreme Court has clearly given out, I think, more than 2-3 judgments in this regard, it's now become a vote bank issue. So and another vote bank issue in Tamil Nadu is Brahmin hatred. So many Brahmins would like to.
That's a good question. I mean, how can what's happening in Tamil Nadu be acceptable? You see,
Yes.
I'm not saying that they should fall at the feet of a Brahmin, but at the same time, you can't create problems for Brahmins because they happen to be Brahmins. So there are so many issues which, in my opinion, need to be taken so that the Hindu system is kept alive in a vital form, not in terms of this is for that marriage and this is for this marriage.
I have a question for M.R.Venkatesh and T.R.Ramesh. We are talking about the denomination and Hinduism. But I want to know, if the denomination is not there, can even a non-denomination Hindu temple, can it be taken over by the government?
Sir, the only protection accorded to the Hindu temples from government takeover is only when it declares through a torturous, self-inflicted process, is to say that it is denominational. Otherwise,
no, I think Jagdish ji asked a very interesting question. If I may say, MRV, if I may.
Okay, please go ahead.
Okay, the 1965 constitutional bench in the STG Pandarasanidhi case, or otherwise known as the Vaidishwaran Koil temple case, it did not go on the basis of a denominational temple. It just went as a temple. And the court said the deputy commissioner or the commissioner or even the court cannot appoint an executive officer to a temple unless a case is made out for such appointment. This is what was followed in the Chidambaram temple judgment that was secured by Dr. Swamy. The court very clearly said you can take over only if there is mismanagement, and the takeover must be only for curing the mismanagement.
So whether in Kallanagar also, very heavy.
In Kallanagar temple recently were argued by M.R.Venkatesh. So whether the temple is denomination or not, of course, I and MRV say that all temples are denominational. That's as Doctor said, that's a subject for another debate now. But why and when a temple can be taken over is laid out clearly in the Sabarimala temple case. The final paragraph in the judgment also says it must be for a limited period, an order in which a period of operation is not prescribed. It is ex facie illegal, arbitrary, and unjust, which means all the orders that have been issued appointing executive officer in Tamil Nadu are unethical, unjust, illegal. And that's what Dr. Swamy has issued a notice 2 weeks ago seeking the government to get out of all the temples.
Yes. And they're mad as hell.
I have another related thing in one of those 7 or 8 issues. If somebody can display on the screen the 7 or 8 issues which are framed, the last issue is whether a person not belonging to a religious denomination or religious group can question a practice of the religious denomination or religious group by. I only want to know, I am a devout Hindu. I may not be belonging to any denomination, but I am against the government control of temple. So can I go in a PIL challenging the government takeover of the temple?
That is not a practice of the religious denomination. That is a practice of the government.
So I can very well go.
Yes, sir.
Yes.
And take others with you.
We are waiting.
No, we have in Maharashtra, we have the famous Pandharpur case. I and Dr. Swamy are the co-petitioners, and we are devotees of Vitthal Rukmini. So we have gone to court to liberate this Pandurang Vitthal Rukmini temple in Pandharpur. So I was looking at from that angle, and Dr. Swamy is fighting numerous other cases where he wants the temple to be liberated, including Lord.
Sir, I have seen Dr. Swamy's points on that. It will take only 15 minutes for the court to listen to Dr. Swamy, another 10 minutes to listen to the government side. They can pass the judgment the very same day because Dr. Swamy has gone on not merely on the denomination aspect, he has gone on 31A, 1B of article. It says any law providing for a endless takeover is invalid, is unconstitutional. We saw that courts are shying away from that question, pertinent question, which is being raised by Dr. Swamy again and again in Uttarakhand temple and again in Pandharpur temple. The court is doing something immoral, constitutionally immoral.
I think our devotees, Warkaris, and the priests of Pandharpur will be quite happy to have this insight into the present thing. Do you think we must wait for the judgment of the review judgment to come before we proceed in the Pandharpur matter, or we can proceed anyway?
Unless the court goes on a very lengthy judgment which covers Article 26D, which says every denomination can administer their own institutions in accordance with law. In accordance with law means I will obey the general law. I will pay taxes. I will pay the electricity bill. I will not obstruct traffic. I will not do constructions which are violations of municipal law. That is what in accordance with law. It doesn't mean in accordance with the HRNC Act or in accordance with Pandharpur Takeover Act. The denomination has a fundamental right to administer its own institutions. It is the court which is denying us, then the politicians, then the bureaucrats.
Okay, thank you. I think we have an extensive discussion, unless Dr. Swamy wants to add something, because he has been.
I would say that in any family, nobody should be by birth Brahmin or Kshatriya or whatever. It has to be what line of work he has taken up. If he is becomes a professor, he can be a Brahmin, even if he was born in a scheduled caste family. That kind of thing you bring, you will unite the Hindus in a very, very big way. And for that we have to create an atmosphere, of course, I believe. But this is some of the things that we need to do to propagate wherever we can is possible.
Arvindji, please
Okay,
conclude.
thank you, Dr. Swamy.
Thank you, Dr. Swamy. Of course, towards the end, Dr. Swamy has raised a new issue which could perhaps be a subject matter of an entire episode for Gyan Ganga. And maybe in future we'll discuss that, because that will be, I mean, a very broad discussion on Varnashram and the Varg or the class system that we have or that is followed legally. Thank you, Dr. Swamy. In fact, Dr. Swamy only initiated the whole issue by identifying those 7 points. Thanks the experts. In fact, the program is much richer today by the presence of two experts in this program. Dr. M.R.Venkatesh, as always, he has been full of knowledge and new perspectives he is drawing to our viewers, and T.R. Ramesh and both MRV, they have been in our program, and our programs have been richer in terms of knowledge because of the presence of these two. Thank you very much, both of you, for coming and joining us on this program. Thank you, Jagdish. Thank you, Ramesh. Thanks the technical team led by Ashish Shetty, Tejas Navalgul, Swaminathan, Gadgi Rakesh, Ishwar Iyer, Ajesh Nair. Uh, though there are issues which these two experts and Dr. Swamy have highlighted today, we will look forward to the hearing in the Supreme Court by the 9-judge bench, and let's see what emerges. It's going to be very eye-opening. Perhaps I hope the 9 judges listen to the recording of this program, not for any influence, not for getting any influence, but just for the knowledge. And as I said, as an amicus, they should consult some Dharmacharya and Shankaracharya. Thank you very much. We'll be meeting again next Sunday, 8 p.m. like this, with a new topic, Dr. Subramanian Swamy and maybe other experts. Thank you. Till then,
Thank you.
Namaskar, Jai Hind.
Namaskar, Jai
Jai
Hind,
Shri.
Jai Shri Ram.